Mr. Speaker, I'm pleased to have the opportunity today to start the debate on my private member's bill C-518. Quite simply, this bill will penalize crooked, law-breaking politicians who fleece taxpayers by taking away their pensions. I was the national director of the Canadian Taxpayers Federation when the scandal surrounding now former Senator Lavigne unfolded, and I, like many Canadians, was appalled by the details of the case. He quite literally stole money from taxpayers. He was ordered to repay tens of thousands of dollars for improper travel expenses. He used his publicly funded staff to do his own personal chores. He was convicted in a court of law for breach of trust and fraud. And yet, though that man currently sits in prison, he is still collecting a taxpayer-sponsored pension because of a loophole. You see, Lavigne technically resigned as a senator before he was kicked out. And when a senator resigns, according to the rules, he gets to hold on to his pension. Only if a senator is forced out of office for breaking the law or is otherwise disqualified will a senator lose his pension. But if a senator quits before he has the chance to get fired, he will be paid a parliamentary pension. That's exactly what Mr. Lavigne did. He fleeced taxpayers while in office, and now he fleeces them still. The Canadian Taxpayers Federation calculates that Senator Lavigne is receiving $67,000 per year from his publicly funded pension. That's more than most Canadians earn from honest work in a full-time job. More recently, we saw Mark Arb, retired from the Senate after it was discovered that he had also been fleecing taxpayers. He qualifies for a pension estimated to be over $100,000 per year. Police are investigating his actions, but should he be charged and convicted, he will be in the same boat as disgraced Senator Lavigne, with taxpayers again footing the bill. Mr. Speaker, this situation is unacceptable. That is why I want to change the law to close the loophole that is currently letting politicians who abuse their office and swindle taxpayers get a taxpayer-funded retirement. That is why this bill, the alternative title is the Protecting Taxpayers and Revoking Pensions of Convicted Politicians Act, will do. First, it will add a clause to the Members of Parliament Retiring Allowance Act to take into account the situation where a senator or a member of Parliament is convicted of an offence which arose out of conduct that occurred while that individual was in office. It does this by using the same mechanism that is already in place for politicians who become disqualified for their offices. The law already takes into account the situation where a senator is deemed disqualified. It states that a senator will receive their pension contributions plus interest and not a penny more as a lump sum when that senator, quote, ceases to be a senator by reason of disqualification or who is expelled from the House of Commons, end quote. Whenever a senator or a member of Parliament is found to have committed reprehensible crimes while in office, whether or not they are still holding that office, they should have their pensions taken away. I'm sure my colleagues will agree with me that we must get rid of the loophole that currently lets crooked politicians keep their pensions if they quit before they get fired. Thus, under this bill, my bill, a convicted parliamentarian will not receive a pension but will be reimbursed only their pension contributions plus the earned interest. The second thing I want to accomplish with this bill is to make sure that it will be applied for all future convictions of politicians, including for past malfeasance. For this reason, I've included a section clarifying that the charges contained in the bill will apply with respect to any person that is or was a member of the Senate or House of Commons and convicted after the date I introduced the bill, which was June 3rd, 2013. Police investigations are currently underway to look into possible criminal breach of trust, theft, or fraud. Charges may be forthcoming, and if any of these potential charges result in a conviction, I would want to know that this loophole was closed in time. Now, some wonder if this bill, which will revoke the parliamentary pension of a convicted politician, is legal. They ask, can the law be modified to repeal an entitlement? Can the law be applied retroactively to the near past when the bill was tabled, and include a crime that occurred before even the tabling date? I can answer with certainty the answer is yes. Yes, we can repeal a parliamentary entitlement, and as I mentioned previously, the law already provides under what circumstances that can be done. Indeed, I believe most analysts will agree there is not an issue on a go-forward basis, that is when the crime, the criminal charge, and conviction all happen after the bill is law, should it become law. But of course, life is not that simple, and we have several difficult cases before us now. They demand a remedy to protect taxpayers. Regarding the retroactivity to convictions after the tabling date of June 3rd of crimes committed before that date, the answer again is yes, and again with certainty. Colleagues, it can be done, for it has already been done. Legislation passed earlier this year in Nova Scotia strips the pension of any lawmaker convicted of a crime for which the maximum punishment is imprisonment for no less than 5 years. The start date for that law was May the 6th, which was when the bill was tabled in the provincial legislature. And the result? In June, an independent MLA lost his pension after pleading guilty to fraud and breach of trust charges arising from an expense scandal. He collected tax dollars after filing 10 false expense claims in 2008 and 2009. Today, he is not eligible to receive an MLA pension. Mr. Speaker, I believe taxpayers expect similar accountability from Parliament. We have an opportunity to stand with taxpayers should any parliamentarian be found guilty of a serious crime in the future. Some have expressed concern that this bill is too harsh. The bar that I set in the bill would strip the pensions away from any MP or senator who commits a crime with a maximum punishment of 2 years or more. Now, during my consultations, it was brought to my attention that there are some crimes in the criminal code with a maximum penalty of 2 years for which I do not think a politician should lose his pension. There are many different crimes, so I won't go through the entire list, but I hardly think that a member of Parliament should lose his pension for being convicted of blasphemous libel. Neither do I think it is necessary to strip a pension away from someone who gives out a false alarm of fire. It is too conceivable that somebody could technically be guilty of those crimes without the offence being so egregious that it should be grounds for losing a pension. I think all honourable members will agree that if we proceed with my bill, we should do so thoughtfully and carefully to avoid unjustly revoking a parliamentary pension. I'm therefore open to suggestions for improving this bill in this regard. The best suggestion I've heard so far, and with which I agree, is to limit the scope and to raise the bar. The bill currently would apply to any federal statute with, again, a penalty of 2 years or more as the maximum. I think it would be fair to limit the scope to only include the criminal code. As I mentioned a moment ago, the bill would apply to violations for which the maximum penalty is 2 or more years. I think it would be fair to raise the bar and only consider indictable offences for crimes in which the maximum penalty is 5 or more years. I will therefore be moving and endorsing this higher 5-year threshold at amendment stage. In doing so, this federal act will be virtually identical to the provincial law in Nova Scotia. I believe my bill is an appropriate response to the unfortunate actions of a handful of some. Both of these modifications will keep the spirit of the bill entirely intact. Fraud and breach of trust would both still result in a loss of pension. The message I want to send is very simple. If a senator or an MP steals from taxpayers, they don't deserve to have they don't deserve to have taxpayers buy them or fund them a gold-plated retirement. I trust all honourable members will agree. Thank you for your time.
Questions and comments? Question et commentaire? I wasn't sure if you were standing for the next speech, but I will recognize the member from Burnaby, New Westminster, assuming he wants to ask a question.
Well, thank you, Mr. Speaker. I certainly appreciate the recognition. I thank the member for putting forward the bill, and the NDP members will be looking to support at second reading. He mentioned in his speech that he would be looking to change the conviction it's contained within Bill C-518 from 2 years to no less than 5 years, which of course targets, as you know, Mr. Speaker, and is parallel to the Nova Scotia law that the NDP government brought in place. And so I certainly appreciate it that the member brought forward the fact that he will be bringing those amendments in. But the other concern that has been raised around this bill that's contained within the Nova Scotia NDP bill allows for a former spouse having court-ordered restitution that can be deducted from the salary of or the pension of the member of the House of Assembly. So I wanted to ask the honourable member if he is looking as well for those amendments so that the spouses or ex-spouses of those MPs that are convicted would still have access to that pension. That was the other concern that was brought forward in terms of his bill.
The honourable member for New Brunswick Southwest.
Thank you, to my honourable, through you, Chair, to my honourable colleague. I have been asked about that, the question of a spouse or dependent and how they might be impacted by this bill. And I have a couple of thoughts on this. The first is that we should not treat ourselves in a manner that is terribly different than ordinary Canadians. And so, for example, if someone goes to prison today and that person has a spouse, that is something that is difficult for that family, but it's something that they do without support from the state. Similarly, I'll point out in my riding, if someone, for example, defrauds a government program, they not only could go to jail, but they also lose funding of that program, say it's the employment insurance, for example. And we don't, as a government or as a country, make special restitutions for those kind of examples. So I'm a bit wary of kind of proceeding down a path where they did in the other place, where members are ejected, but they continue to collect their benefits in a way that I think is a bit offside with Canadian taxpayers. So I'll point out my solution, which is that should a member find themselves in a situation where they were disqualified from their pension, under this bill, the pension that had been, the amount that had been contributed by that member would be returned to that member with interest. And and that's no small amount. I mean, we currently pay about $11,000 or $12,000 a year towards our pensions, and that's going to rise to about $38,000 a year starting after 2016. And if you look at that amount, say over 6 or 10 years, you begin to approach a fairly healthy amount between $300,000 and $500,000 approximately. So that addresses the honourable member's concerns, I think, to a degree. But having said that, if that's an avenue that other members want to pursue, I'd be open to hearing about it. But again, I wouldn't want to have a loophole that is too large here, because the point of this bill is to send a signal to people: don't break the rules. And if you don't break the rules, the pension will be there for you.
Questions and comments? Question et commentaire. The honourable member for Bonavista, Gander, Grand Falls, Windsor.
Thank you, Mr. Speaker. I want to point out something to my colleague. He mentioned about some of the offences in question that were up to 2 years. That certainly he would not be in favour of revoking pension benefits to any particular member of either house. But does 5 years really do that in some cases? Because remember, this is just what he says is a maximum sentence. It's not what they have been convicted of necessarily. It runs up to a maximum of 5 years, which certainly could cover a whole array of charges. I'm just trying to test whether or he can say definitively that 5 years gets over that level of comfort that he's talking about.
Honourable member from New Brunswick Southwest, you have about 45 seconds.
Okay, well, I believe it does, because if you go through the criminal code, you'll see those crimes that are generally covered by that involve crimes that, first and foremost, involve kind of scheming, if you like. They're not crimes you're going to fall into by accident. And more to the point, it's a minimum, it's a maximum penalty of 5 or more years. And that does disqualify a whole range of activities that someone could fall into through a lapse of judgment, for example. So I'll have to ask the member, because I'm short on time, to kind of review the criminal code. But what's important to avoid here is an example where someone like Leving, who is found guilty of breach of trust, is then sentenced to 6 months keeping his pension. So it was designed not with the penalty that's handed out the jail time, but actually what crime the individual is charged with. And I believe it has to be a serious crime that would only trigger that would trigger the loss of a pension. Thank you.
Resuming debate.